How do you determine pain and suffering as an element of damages in a personal injury case? So pain and suffering is what we call an element of damages. It's non-economic damages. It's the type of damage that you can't put a specific number on. It's not like a medical bill or any other kind of expense that you have, a repair bill for the vehicle or something where there's an actual number. How much pain and how much suffering does someone go through as a result of an injury is a difficult question to answer. That's left up to a jury to decide if the parties can't agree amongst themselves and settle the case. So for settlement purposes, it's hard to get an insurance company to put a significant value on pain and suffering, but the more serious the injury, the stronger the position your lawyer would have to argue that the pain and suffering could be substantial. Some lawyers use different strategies to argue pain and suffering amounts. If the client ended up having surgery, some lawyers will calculate how many days will they be living for the rest of their life and say that come up with a monetary amount per day, 50 cents a day, $1 a day. How much is it worth to be in pain? When you start adding that up, $1 a day, $100 a month, some lawyers use different numbers. But in order to persuade a jury that the amount that you're asking for pain and suffering is reasonable, you have to show the jury what the injured party is going through. Sometimes we use day-in-the-life videos if it's a more serious injury or a catastrophic injury. We really want the jury to see what that person goes through every day in terms of their daily routine and how their activities of daily living have been affected by an accident. Do they need assistance getting up, getting dressed, doing the things that they used to be able to do on their own? Those are the types of cases where a day-in-the-life video would be effective. Otherwise, we're able to show, sometimes based upon what the person does for a living, what the restrictions and what the requirements are of their job, what kind of lifting they have to do, what kind of bending they have to do. If we're able to show that somebody's normal activities are affected, then their pain and suffering award usually will increase with that. If somebody's a parent and they have difficulty playing with their children or lifting their children or doing sports and other activities with their children after they've been injured in an accident, that significantly affects the value of their claim. It's very difficult to just say, if you have this injury, this is what your pain and suffering award is. Are you married? Do you have a spouse? Do you have other significant folks in your life that are affected by your injury? Are you living alone? That, believe it or not, would play a role, because if you have a spouse, they also have a claim. It's called loss of consortium in Florida. It's not exactly a pain and suffering award, but if as a result of your injury, you come home in a miserable mood because you're in pain all the time and you can't do certain things, your spouse has a damage claim for that. So that kind of gets tied into a pain and suffering award and how this type of an injury that you have would affect your family. So keep in mind that your lawyer sometimes needs to be a bit creative in coming up with a reasonable argument, either to present to the insurance adjuster or in trial for a jury, to come up with a reasonable way to help them to calculate your non-economic damages without just asking them to make up a number.